meeting now is now in public session, members. And can I refer members to item number 8 on the agenda, which is the draft minutes? And can I refer members to the draft minutes of proceedings, and they're at pages 314 to 324 of your meeting pack. Our members contend that the draft minutes of the meeting on the 11th of December 2025 are a true reflection of proceedings. Yep, thank you, members. Moving on to item number 9, matters arising. There are no matters arising. So we'll move on now to item number 10, which is Regulation EU 2025-2509 on the safety of toys. And we are now will have departmental oral evidence. And just to inform members, this item will be recorded by Hansard. And can I refer members to relevant pages at page 7 to 144 of your meeting pack?
Apologies. You'll go on to explain about the issue with the Executive Office. There was supposed to be departmental evidence.
Yeah.
So.
Obviously, just to remind members that the committee previously considered the proposed EU Act in some depth, and this is detailed in your meeting packet, pages 15 to 16. In relation to the scheduled evidence session today, can I refer members to a response from the Executive Office at page 22 of your tabled papers? Officials state that there is no department placed to provide the committee with an assessment of impact or evidence in relation to this Act. The Executive's position is that product safety sits with the Office of Product Safety and Standards, which is under the Department for Business and Trade. Here, this responsibility sits with councils, and it's not within the policy remit of any NI Civil Service Department. Solace, as you can recall, provided some comments on the Act when it was at proposal stage, with relevant correspondence can be found at page 108 to 115, as did the British Toy and Hobby Association, and that can be found at page 116 to 118. Can I advise members that the British Government has also provided an explanatory memorandum on the Act, which can be found at page 126. Can I advise members that a response from the First Minister and Deputy First Minister to the Committee's requests regarding both this EU Act and the product being developed by the Executive Office following the Committee's review of operations can be found at page 99. And this offering an informal meeting with myself and the Deputy Chair and TEO officials to discuss these matters. Our members content for myself and the Deputy Chair to attend with TEO officials, hopefully early next week.
Yes.
Yeah, thank you, members. Under paragraph 8 of Schedule 6B to the 1998 Act, the committee must decide today whether or not to hold an inquiry into the published replacement EU Act that has been notified. Should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. Just so having regards to that information, the legal advice on whether it appears likely that the replacement EU Act significantly differs in whole or in part from the content or scope of the EU instruments which it amends or replaces, and bearing in mind the information received from stakeholders and the British Government in relation to whether it appears likely that the Replacement Act would have a significant impact specific to everyday life of communities here in a way that is liable to persist. I would now like to ask the members, do they wish to hold an inquiry into Regulation EU 2025-2509? And I'll have David first, and then Steve, and then Declan.
Chair, clearly, as with a meeting to have, and there's still information to be gathered to understand the fullness of this, I think it's common sense, to have the inquiry to allow that time for us to gather that information. And I would suggest also to seek more information from UKG, whether that is appealing for relevant officials to appear before us to answer questions. I think that would probably be helpful as well.
David, Steve?
Yeah, just a question of clarification for the committee. My reading of this is that nobody's responsible for safety regulations when under these directives within Northern Ireland, because nobody's actually taking responsibility for it. I think this could be a significant problem, not just for toy directives, but it might be other areas as well. In your discussions with the TEO, and are you also talking to the Economy Department?
We are, yes.
Could you, again, I'm proposing from this committee through the Chair and the Deputy Chair to raise that question, because I think this is a fundamental safety issue. If nobody's responsible for the safety of toys, what else are they not responsible for?
Okay, Steve. Declan?
Yeah, I actually agree that it would be useful in that meeting to raise that particular point, but I don't see any basis for an inquiry. If you look at the British Government explanatory memorandum, the logic for not proceeding with an inquiry, I think, is set out in 25, 26 and also then in 33, so I would be opposed to holding an inquiry.
Is there a formal proposal on the table for an inquiry?
I'm certainly proposing an inquiry. I think it's common sense to allow. I mean, if we have these meetings and there is information gathered at those meetings that could be significant to our consideration, we have, unless we have an inquiry, we have no channel in which to discuss or consider that information. So I think, you know, I certainly would be proposing we have an inquiry to allow that.
Do you need a seconder for that?
I'll second it.
No, you don't need it.
We don't take the proposal.
Yeah, so, no, we'll take the proposal. Any other comments?
Well, on that very point, I mean, again, I think we're into the territory here of stretching the elastic around the remit and the scope of this particular committee, so therefore I would reiterate my opposition to holding an inquiry at this stage. I'm quite happy for the Chair and the Deputy Chair to proceed and conduct a meeting with TEO.
Proposals are on the table.
Yeah, so.
Sorry, Chair. Just to add, I think the fact that there hasn't been evidence from departments means we don't have as much information as we would like. So, I mean, I support the call for the UK government to reach out to the UK government to get more input from them. I don't particularly mind an inquiry if that's a way of us getting that information, but preference would be if we could get information from the UK government. So I mean, I'm minded to support, but I think that maybe we could get additional information from the UK government first would be my preference before deciding on an inquiry.
And if there's little comes back that affects it, you know, it could be a very short, you know, item at some point, but I do think just keeping it live is preferential.
Through the Chair, I think the problem with that is the deadline for an inquiry is
22nd
22nd.
January. We would need to agree the report. There's no reason why you can't ask for the information outside of inquiry, but I mean, you could have an inquiry as well.
Doesn't have the weight without it. Sorry, through the Chair.
Through the Chair, so it is possible to take on Kate's point that we can seek information whilst having an inquiry and try and gather the information that's required in parallel.
That's what the inquiry is.
Yeah.
There's no reason that you can't do either or both.
Okay. That's it, tabled.
Thank you.
One just wants to comment.
No, Chair, I'm happy enough, thank you.
Yes.
So on David's proposal that we proceed with an inquiry, seconded by
Yeah.
Steve, just to show of hands.
Yeah.
Yeah. That's fine, thank you. Yeah, that's passed. Thank you, members.
I'll just read out that result just for the record, okay? An inquiry into the regulation 2509 on toys. Ayes, we have Kate Nicholl, Owen Tennyson, David Brooks, Jonathan Buckley, Peter Martin, Steve Aiken, and noes, we have Ciara, Declan and Cahill. So the proposal's carried.
Thank you. So just can I refer members now to page 140 of your meeting pack. So can I ask members to consider and agree the inquiry timeline? So this timeline includes scheduling an oral evidence session with departmental officials on the 15th of January. This is likely to be an issue. The clerk did ask whether the Office of Product Safety would be available to give oral evidence to the committee, but they haven't received a response. Do members wish to a formal request to be made with the final report to be agreed on the 22nd of January? Yeah. Thank you, members. Can I seek agreement to ask for views on the Act via Citizen Space Survey from the key representatives of businesses and civil society identified by RAISE at page 141 of your meeting pack with a closing date of the 18th of January? Thank you, members. Can I advise members that the Citizen Space Survey will be promoted on a social media platform and that anyone will be able to respond?
Yep.
And can I advise members that in line with agreed processes, views on the EU Act and its impact on communities here and details of the position in England, Scotland and Wales will be requested from the British Government? Okay, members. Okay, members, we'll now move on to item number 11 which is Directive EU 2025-2456,
6.
as regards reattribution of scientific and technical tasks to the European Chemicals Agency. We're now going to receive departmental oral evidence, and can I inform members that this item will be recorded by Hansard? So can I refer members to the relevant papers at page 145 to 175 of your meeting pack? Can I inform members that an assessment of impact from the Department of Agriculture, Environment and Rural Affairs can be found at page 25 of your tabled pack? Can I inform members also that the British Government's EM can be found at page 159 of your meeting pack? And just likewise to remind members that the committee will need to take a decision on whether to hold an inquiry into this published Replacement EU Act, and will do so following the evidence session. The same applies for the other published acts that we will be considering here today. So can I warmly welcome Tommy McNamara, Head of Branch and Policy Lead for Restrictions of Hazardous Substances from the Directive from the Department of Agriculture, Environment and Rural Affairs, and Niall Chambers, Deputy Director of Environmental Resources Policy Division with the Department. So you are very much welcome, Niall and Tommy, and Happy New Year to you both. And when you're ready, could you please brief the committee? Thank you.
A small correction, Nigel.
Oh, Nigel, sorry.
Good morning. Thank you for the opportunity to brief the committee on Directive 2025-2456, amending Directive 2011-65 as regards the reattribution of scientific and technical tasks to the European Chemicals Agency, which is commonly referred to as the CHA, and which I refer to as the CHA to save a mouthful every time I use the terminology. I understand the committee has already received a copy of their assessment of the impact from the directive, and I also understand they've received a copy of the UK Government Impact Assessment because we weren't able to provide a link to it. It hadn't been published at the time of producing this. I'll briefly set out an overview of the changes, the anticipated impact, and how much engagement there's been on this particular issue. Directive 2011-65 provides the EU regulatory framework on the restriction of use of certain hazardous substances in electrical and electronic equipment. This policy area is currently reserved to the UK Government, and there's no devolved aspect to it. Currently, there are 10 restricted substances listed, and that includes lead, cadmium and mercury, which account for over 99% of the exemption applications. And that is where manufacturers seek permission to manufacture electronic equipment using one of these restricted substances in excess of the restricted limits laid down in the directive. Directive 2011-65 is listed in Annex 2 of the Windsor Framework, and as such the amending directive will apply fully in Northern Ireland. Directive 2025-2456 was published on the 12th of December 2025 and enters into force today, January 8th. It's relevant, however, that the amendments will only actually apply from the 13th of August 2027, effectively providing for a substantial lead-in period. This directive is linked to the EU's One Substance, One Assessment package, which is part of the chemical strategy for sustainability. The overarching goal of the package is to streamline the EU's chemical risk assessment framework by reducing duplication, ensuring consistency and transparency, and by fully utilising the use of scientific expertise and resources across a suite of EU legislation. The policy rationale underpinning the directive is twofold, namely to ensure the allocation of responsibilities make the best use of expertise and resources, and the adoption of transparent and inclusive procedures delivering high scientific quality outcomes. To achieve these objectives, scientific and technical work on chemicals needs to be consolidated in the relevant union agencies, with obligations on union agencies to cooperate in developing assessment methodologies and exchanging data and information. This simplifies the current chemical regulatory framework, improves the quality and coherence of safety assessment across union legal acts, and ensures that existing resources are used more efficiently. The directive does this through a number of amendments to Directive 2011-65, including a revised application procedure with new and revised timelines whereby an application for granting, renewing or revoking an exemption must be made to the ECHA. This is a departure from the current process where an application is currently made to the EU Commission. In the case of an application for a new exemption, or where the ECHA considers it appropriate, a requirement to request the opinion of the Committee for Socio-Economic Analysis and the Committee for Risk Assessment. These are both EU committees, who, among other things, will provide clear guidance to the Commission on granting, renewing or revoking an exemption. There's also an obligation for the Commission to undertake a review based on restriction dossiers prepared by the ECHA of the list of restricted substances listed in Annex 2 to Directive 2011-65, and that review must take place at least every 4 years. And finally, to initiate a procedure for review and amendment of the list of restricted substances. When we look at the impact on businesses, DARE's assessment is that it is likely that the directive will not have a significant impact specific to everyday life of communities in Northern Ireland in a way that is liable to persist. The relevant amendments will result in high-level reattribution of scientific and technical tasks among EU agencies and increase the efficiency of EU internal processes. There's likely to be a modest increase in EU-level resources to support the ECHA's new responsibility. These costs are at an EU level and there are no anticipated impacts in Northern Ireland. There is potential for some Northern Ireland-based stakeholders to experience indirect costs or benefits depending on how the new procedures affect compliance, transparency and efficiency with the EU's new system. It's relevant, however, that none of the costs or benefits will be incurred due to any additional barriers to trade. It's also DARE's assessment that non-application of the directive will not have a significant impact specific to everyday life of communities in Northern Ireland in a way that is liable to persist. Should the directive not apply, the consolidation of chemicals work streams within EU agencies will still occur and decisions on granting, renewing or revoking an exemption would continue to be undertaken by the Commission. Neither DARE nor the UK Government carried out any public consultation in respect of this directive. The European Commission did consult the public on the one substance, one assessment approach, which generally received favourable feedback from stakeholders. The EU determined that a formal impact assessment was not required, given there is little discretion of the policy choice to achieve the stated objectives of the directive. However, with regards to the one substance, one assessment package, including the reattribution of tasks, the Commission stated that the proposal is expected to improve the efficiency, effectiveness, coherence and transparency of EU processes for chemical assessments for the benefit of all stakeholders. Citizens and the environment will benefit from better protection from dangerous chemicals as a result of the more efficient and effective assessment processes. There was no evidence of Northern Ireland stakeholders having any input to any of the EU assessments. I am conscious that in setting out the background, I have referenced existing EU legislation on the restriction of the use of hazardous substances in electrical and electronic equipment. However, I think it's important to emphasise that the directive being considered today relates solely to the procedural reattribution of tasks and the efficiency of EU internal processes. That concludes the presentation, and we'd be happy to answer any questions that you may have.
Steve?
Yeah, just a couple of ones. What interaction have we ever had with the Committee for Socio-Economic Analysis and the Committee for Risk Assessment?
On this particular issue, to the best of my knowledge, we haven't had any impact with them or interaction with them at all.
So,
just at a DARE level, possibly at UK government level, but at a DARE level.
Doesn't look like it from the EM, so it doesn't, as if they've had much interaction with it. So basically, everybody is looking for any sort of derogation or derivation from the existing rules within the procedures. It now has to go through the Committee for Socio-Economic Analysis and then also through the Committee for Risk Assessment at the same time.
Well, whoever makes the application doesn't have to do that. The application goes straight to the European Chemicals Agency. They then engage, that's their responsibility. There's an obligation on them to engage those other committees.
Yeah.
And those other committees. So it's all about internal EU processes. So at an industry level, you want to make an application, you make the application, you send it in, and then you will be, unless they won't require any additional information of you, then, so all you will do is make the application and get the outcome, so that won't change.
Okay.
Jonathan?
Thank you, Chair. Thank you very much and Happy New Year. Firstly, I'm right in saying you said DARE have had no consultation with stakeholders in relation to this?
That's correct.
Yeah. DEFRA, to your understanding, have they had any consultation with?
No, they haven't had.
No, they haven't. Okay, so that's first point. What is the trade flows? Has there been any analysis, particularly I'm thinking along divergence of chemical supplies and other supplies from GB to Northern Ireland? Have we any holistic picture of what that looks like at present?
Well, as far as chemicals concerned, this doesn't, although this is a chemical-based directive, it isn't concerned with the flow of chemicals, it's concerned with the flow of possibly electronic equipment. There hasn't been, although there's legislative divergence, operationally there's very little divergence, and any time an exemption is granted by the EU, the position in GB has been that they have mirrored that, so there has been no disruption to anything. It's very closely aligned.
You would accept that legislative divergence could ultimately lead to trade divergence in the future? Because you're
not on this.
So if I'm looking at your assessment, you've said the application of the directive is not likely to have a significant impact, but also the non-application of the directive is unlikely to have an impact. So it's quite a position. In the text, it talks about the EU text. It talks about seeks to improve cooperation among union agencies in the area of chemicals. What local representation is involved in that?
To my knowledge, from a Northern Ireland perspective, I don't think there's any, because we don't form part of the union agencies, even at a UK level. But this, to quote someone who gave me a good analogy of this is basically the EU moving the furniture around, as Nigel said to me. So it's all about their internal processes. Therefore, it won't disrupt the actual use of these substances and the electronic equipment from an industry point of view won't change. It's all about EU internal processes.
And to date, you've said that the UKG are likely to mirror some of these changes. Am I correct in that? No?
Not in that, no. What I'm saying is, and apologies if I didn't make this specifically clear, is that the UK government to date have mirrored any exemption granted, and that means therefore that there are, and we have no indication that will change, because they're usually granted, a lot of this exemptions are granted in respect of medical devices, a large proportion. So if the exemption is granted for the production of certain medical devices, the UK government generally just reciprocate, and then there's no issue. There hasn't been any issues to date on this whatsoever.
Okay.
Could I just ask one then, Tommy, is it specifically administrative? It's purely administrative changes?
Purely administrative and changes within the EU context itself.
Any other members want to ask any questions? Can I thank then both Tommy and Nigel for your presentation this morning. Under paragraph 8.1 of Schedule 6B of the 1998 Act, the committee must decide today whether or not to hold an inquiry into the published replacement EU Act that has been notified. Should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So having regard to that, the legal advice on whether it appears likely that the replacement EU Act significantly differs in whole or apart from the scope or content of the EU instruments which it amends or replaces, and the departmental assessment on whether it appears likely that the Replacement Act would have a significant impact specific to everyday life of communities here in a way that is liable to persist. Declan, do you want to ask questions? Okay. Do members wish to hold an inquiry into Regulation EU 2025-2456?
No. No.
No? No? Okay, members, thank you. Can I advise members that the committee's decision will be published on its webpage? So we're now going to, if you are content, yeah, you okay to move on, yeah? Just refer members now to the inquiry timeline at page 1. Oh, sorry, I'm getting confused here now. We'll move on to the next item, obviously, which is item number 12, members. So it's Regulation EU 2025-2457 as regards the reattribution of scientific and technical tasks and improving cooperation among union agencies in the area of chemicals. Just to inform members once again that this item will be recorded by Hansard. And can I refer members to the relevant papers at pages 176 to 217 of your meeting pack. Inform members that the assessments of impact from the Department of Agriculture, Environment and Rural Affairs, the Department of Health and the Food Standards Agency can be found at pages 205 to 212 of your meeting pack. and to inform members that the British Government's EM can be found at page 191 of your meeting pack. So can I welcome, it's David Wilson, who is the Senior Principal Officer from the Department of Health, Caroline Barry, who is the Head of Chemical and Industrial Pollution Policy Branch, Department of Agriculture, Environment, Rural Affairs, and Aoife Corrigan, who is the Deputy Principal from the Department of Agriculture, Environment and Rural Affairs. So you are very much welcome and Happy New Year to you all. And just whenever you are ready, I'll invite you then to brief the committee.
Thank you, Madam Chairman and members of the committee, for giving me the opportunity today to speak to you on the EU Regulation 2025-2457 of the European Parliament and Council of the 26th of November 25 on the reattribution of scientific and technical tasks and improving cooperation among union agencies in the area of chemicals. Now, as you already said, my name is Caroline Barry. I'm currently head of the DERA Chemicals and Industrial Pollution Policy Branch. This Act came into force on the 1st of January this year and forms part of the European Union's One Substance, One Assessment package under the EU's Chemical Strategy for Sustainability, which was published in October 2020. The overarching goal of the package is to streamline the EU's chemical risk assessment framework by reducing duplication, ensuring transparency and consistency, and by fully utilising the use of scientific expertise and resources across the EU legislation. The purpose of Regulation 2025/2457 is to facilitate the reallocation of scientific and technical tasks and improve interagency cooperation. It aims to simplify the current framework, improve the quality and coherence of safety assessments across Union legal acts, and ensure that existing resources are used more efficiently. It does this by making amendments to a number of EU regulations, namely Regulation 178/2002, and this establishes the general principles and requirements for food law in the EU, ensuring food safety and the establishment of the European Food Safety Authority, the EFSA. Also makes changes to Regulation 401/2009, which establishes the European Environment Agency and the European Information and Observation Network. Furthermore, it makes changes to Regulation 2017/745, known as the Medical Device Regulation, which establishes a comprehensive framework for the regulation of medical devices in the EU, ensuring high standards of safety and health. Furthermore, the fourth piece of regulation makes changes to is Regulation 2019/1021, and it aims to protect human life and the environment, prohibiting and restricting the production and use of persistent organic pollutants, also known as POPs. Now, of these regulations, Regulation 401/2009 is not covered by the Windsor framework, and as such, these changes do not apply in Northern Ireland. Regulation 2019/1021 is covered by the Windsor framework and falls within DERA's remit. Furthermore, DERA is the competent authority responsible for enforcing POPs in Northern Ireland. The amendment of the EU POPs regulation expands the tasks, workload and remit of scientific committees within the European Chemicals Agency and Commission concerning persistent organic pollutants in waste. And as such, these primarily administrative changes result in no new burden for DERA. Therefore, DERA does not envisage any significant impacts to the public or businesses in Northern Ireland stemming from the Act in relation to POPs. There is likely to be a very modest increase in the EU level resources needed to support ECHA's new responsibilities, and these costs are at an EU level and not directly assigned to any individual member state or Northern Ireland. There is potential for some Northern Ireland-based stakeholders to experience indirect costs or potentially more likely benefits depending on how the new procedures affect compliance, transparency and efficiency with the new EU's new system. And overall, it's expected that the changes introduced by these regulations will make ECA's work more effective and coherent. Thank you, and I'll now pass over to my colleague David Wilson from the Department for Health.
Thank you, Caroline.
Thank you, Chair, and good morning, members. I'm David Wilson, Senior Principal Officer in the Department of Health. The Department of Health interest in this regulation is limited to the amendments to the Medical Device Regulations, EU 2017/745, and its application. This regulation applies in Northern Ireland under the Windsor Framework, Annex 2, on Heading 21 on medical devices. The Department for Economy also has an interest in this regulation, as Northern Ireland medical device manufacturers will be following these regulations, and we have liaised with colleagues in DFE and agreed that DOH would lead today in the committee to present the anticipated impact. The amendment to Regulation EU 2017/745 tasks the European Chemicals Agency, ECHA, with updating existing guidelines on conducting risk-benefit assessment and scientific advice and guidance on specific substances. Article 3 of the proposed EU regulation amends Annex 1 of 2017/745 to task the ECHA to provide risk assessment, scientific advice and guidance on specific substances which are carcinogenic, mutagenic or toxic to reproduction, and substances which are classified as endocrine disruptors for human health. Furthermore, it tasks the ECHA with updating existing guidelines on conducting a risk-benefit assessment of the presence of phthalates within these substances. It also aligns the hazard class description of endocrine disruptors. This regulation with respect to medical devices allocates tasks to the ECHA, the task of the provision of expert advice and guidance. The EU's assessment of this impact to the ECHA is low. From a health economy perspective, the overall impact is negligible, with no increase in burden to the delivery of health or Northern Ireland manufacturers. There are amendments affecting EU internal mechanisms for management or specialised committees to provide relevant advice with no practical implications. I will provide some report on behalf of our colleagues in the Food Standards Agency, and with regard to the amendments of Regulation 178/2002, General Food Law. These have been considered by the Food Standards Agency insofar as they relate to the work of the European Food Safety Authority. The EFSA, the Food Safety Authority, is not a decision-making body. Its primary role is to provide independent scientific advice in relation to the safety of food and feed. Any scientific advice or safety opinion produced by the EFSA is used by the Commission and EU Member States to formulate risk management decisions to safeguard public health. As the changes brought forward to this regulation are tightly focused on the way in which the EFSA engages with and cooperates with other risk assessment bodies, the FSA do not expect these changes to result in any impact on outcomes for consumers, industry or regulators in Northern Ireland, as they are internal to the EFSA's ways of working. Thank you.
Thank you. Just open the floor. Any members have any questions they'd like to ask our officials?
Well, just through the chair, this seems to be like the similar sort of evidence we had from DERA. It's about tidying up and looking at sort of...
Procedurals, yeah.
Okay.
And I thank you all for this morning. Thank you. So, just I'm going to ask members, is that you complete? Yeah? Yes. No? Thank you. So, just under paragraph 8.1 of Schedule 6B to the 1998 Act, the committee must decide today whether or not to hold an inquiry under the published Replacement EU Act that has been notified. Should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So can I ask, having had regard to the legal advice this morning and whether it appears likely that the Replacement EU Act significantly differs in whole or in part from the content or scope of the EU instruments which it amends or replaces, and given the departmental assessments and whether it appears likely that the Replacement Act would have a significant impact specific to everyday life of communities here in a way that is liable to persist, do members wish to hold an inquiry into Regulation EU 2025/2457?
No.
No. No. Thank you, members. So just to let members know, the committee's decision will be published on its webpage. So if members are content, we'll move on to item number 13 on the agenda, which is Regulation EU 2025/2650 as regards certain obligations of operators and traders. Can I inform members that this item will be recorded by Hansard? And can I refer members to the relevant papers at pages 218 to 258 of your meeting pack? Just to inform members that an assessment of impact from the Department of Agriculture, Environment and Rural Affairs can be found at page 250 of the meeting pack. And likewise, can I inform members that the British Government's explanatory memorandum has not yet been received? Can I remind members that the committee was notified of the proposed EU Act and heard evidence from the Department of Agriculture, Environment and Rural Affairs officials at our meeting back on the 11th of December. The Hansard transcript from this meeting is at page 243, and written answers on the proposed Act are at pages 248. At that meeting, the committee agreed to monitor the proposal and invite the Chief Veterinary Officer to give evidence on the published EU Act. The Chief Veterinary Officer is here today to brief the committee, so can I welcome Brian Dooher, who's the Chief Veterinary Officer with the Department of Agriculture, Environment and Rural Affairs, and Catherine Fisher, who is the Director of the Department of Agriculture, Environment and Rural Affairs, Windsor Framework Implementation Directorate from the department. So can I very much welcome Catherine and Brian to present the evidence, and Happy New Year to you both. So just whenever you are ready to present to officials.
Thank you, Chair and members, and Happy New Year to you too, and thank you for the invitation to come in and speak to you today. So, as you've noted at our previous attendance on the 11th of December, the EU Deforestation Regulation, or EUDR, refers to Regulation EU 2023-1115 on the making available on the Union market and the export from the Union of certain commodities and products associated with deforestation and forest degradation, and repealing Regulation EU 995/2010. The aim of the regulation is to reduce deforestation and forest degradation. As a brief reminder, the EUDR lays down rules regarding the placing and making available on the Union market, as well as the export from the Union, of relevant products that contain, have been fed with, or have been made using the following 7 commodities: cattle, cocoa, coffee, palm oil, rubber, soya and wood. In particular, the EUDR aims to ensure that those commodities and relevant products are placed or made available on the EU market or exported only if they are deforestation free, have been produced in accordance with the relevant legislation of the country of production, and are covered by a due diligence statement. The EUDR was originally delayed by 1 year through Regulation EU 2024-3234. Subsequently, the present Act was proposed on the 21st of October 2025 to further delay the application of EUDR by 6 months and introduce several simplifications. In November 2025, the EU Council and Parliament voted to amend the proposal further to increase the application delay to a 1-year period and to add further simplifications. A provisional political agreement was reached on the 4th of December 2025. On the 17th of December, the EU Parliament adopted the targeted amendments to EUDR. The regulation which is being considered today, Regulation EU 2025-2650 of the European Parliament and of the Council of 19th of December 2025, amending Regulation EU 2023-1115 as regards certain obligations of operators and traders, was then published in the Official Journal of the EU on the 23rd of December 2025 and entered into force 3 days later. Regulation 2025-2650 enforces the additional 1-year delay to the application of EUDR, with it now applying to large and medium enterprises from 30th of December 2026 and micro and small enterprises from the 30th of June 2027. As noted at our previous attendance, the regulation also introduces further simplifications to EUDR. Regarding obligations related to due diligence statements, only operators first placing relevant products on the EU market are now required to submit due diligence statements. Furthermore, only the first downstream operator on the supply chain is responsible for collecting the reference number of these statements. Micro and small primary operators are only required to submit a one-time simplified declaration and will receive a declaration identifier, which will be sufficient for traceability purposes. They may also replace the geolocation of plots of land in their simplified declaration with a relevant postal address. Other key points of note include that certain printed products, such as books, newspapers and printed pictures, are no longer in scope of the regulation, and that the European Commission must conduct a simplification review and report by 30th of April 2026. This will evaluate the impact and administrative burden of the EUDR, particularly for micro and small enterprises, and may, where appropriate, be accompanied by a legislative proposal. Finally, the general review date for the EUDR is postponed by 2 years to the 30th of June 2030. The EUDR and Regulation EU 2025-2650 are primarily focused on the trade of goods and their impact on global forestation, and as such they are reserved with responsibility sitting with the UK Government. The Department for Environment, Food and Rural Affairs, DEFRA, leads on the EUDR, and DERA does not currently have a role in its application. DEFRA, as advised that the UK Government, is currently considering how best to implement deforestation policy across the UK, that it is aware that businesses require certainty on the approach to deforestation policy, and that it will provide more guidance for businesses as soon as possible. Moving on to the impact on Northern Ireland, the UK Government has not yet clarified the extent of the application of the EUDR itself in Northern Ireland, and given this current lack of clarity, the delay to implementation of EUDR applied through this regulation is welcome. The further 12-month postponement will give traders and operators additional time to prepare and time for DEFRA to confirm the relevant arrangements. It does not appear likely that the application of the amending EU Act would have a significant impact specific to the everyday life of communities in Northern Ireland in a way that is liable to persist. In the short term, there would be no change to the current position as the regulation delays the application of obligations pursuant to EUDR. Furthermore, the simplifications introduced are likely to be welcomed by local businesses. Although DERA has not undertaken any engagement on the issue, we expect this, given the potential to reduce reporting requirement and administrative burden. It does appear likely that not applying the amending EU Act would have a significant impact specific to the everyday life of communities in Northern Ireland in a way that is liable to persist. If the amending EU Act was not applied, obligations pursuant to EUDR would be delayed in the EU but not in Northern Ireland. This would place operators and traders here at a disadvantage compared to EU member states, third countries and GB. I hope you find this overview useful, and I thank you for your time and welcome your questions.
Okay, Catherine. Brian, are you going to present, or is that?
No, that's
okay.
an overview there, and
Okay.
happy to take questions as required.
Okay, so I'm going to open it to the floor. Just to remind members that the questions should focus primarily on the published replacement EU Act under consideration today. So, Jonathan?
Yeah, thank you, Chair. And I know that obviously this is the official delaying of the EU deforestation regulation, and I suppose that probably justifies some of the concerns that I and others have expressed regarding the original and overarching legislation, which this committee was not in situ whenever it was passed. But again, it did point to concerns that I would have had around supply chains, and particularly those sourcing from global markets and for GB in terms of UK food security. So, and the supply chains. Just to ask, in specific to Northern Ireland, so you did say that DERA hasn't consulted stakeholders on this particular, I'm right on that. Would it be your intention to do so?
Well, because the department doesn't currently have a role in EUDR, so what we've done is any queries that we have, we've passed them on to DEFRA, because they're leading on this.
Yeah. So it hasn't been clear who the competent authority in Northern Ireland would be for enforcing the EUDR if it did come into place. So do we know, or are we any more clarity on who that might be?
No, we're awaiting clarification from DEFRA on the application of EUDR and also on who the competent authority will be.
Okay, thank you.
Thank you.
Okay, Steve?
Yeah, just to follow on from Jonathan there. I think it's in Hansard, because we asked the question about this before, and I think you said you would engage when you saw the formal proposals with stakeholders.
The formal proposal?
When it was published.
Oh, DEFRA said it would engage with stakeholders.
No, you did, Dara.
Yeah. Well, we will engage with stakeholders.
So it says, Ms Fisher, we have not engaged directly with stakeholders because it sits with the government. However, I think your decision question to DEFRA, which engaged with stakeholders, it tells it's conducting ongoing engagement in business, and then it says, where it actually says you will engage when you've seen the formal proposal.
Well, we'll engage to give them an update and to let them know that the application of the UDR has been delayed by 1 year. So that's the only update that we have at the moment. So that's what we have put all the stakeholders on a list, and then we'll update them to let them know that it's been delayed.
Oh, that's my apologies. I didn't read it that way. I'm sorry about that.
Okay, no problem.
Yeah.
David?
Thanks, Chair. You had taken concerns from stakeholders and passed them to DEFRA. Can I ask how that, in terms of your own assessment and what impact it will have, was this just a case of taking something handed over to DEFRA, or have you analysed those concerns and considered those concerns yourself and coming to your own conclusions?
No, they've been passed on to DEFRA because DERA doesn't currently have a role on EDR. But I don't know, Brian, if you want to add anything.
So you've given an impact assessment on this, and you know that stakeholders within Northern Ireland have views on it, but in order to keep yourself clean of responsibility, that's what I'm hearing. You're not considering those concerns. It seems negligent to me that the department would be aware that there are concerns within the industry, but will not consider them when coming to its own conclusions. The conclusions may well have been the same. My concern is, if you're aware of concerns, why would that not inform the view that you come to?
Well, the impact assessment is in relation to the delay of the application of a UDR, so that's what the impact assessment and the impact that we've described is on the delay of a UDR.
No, I understand that, but you've deemed it relevant.
So the concern that we've had from stakeholders have been on the application of a UDR itself, which we have passed on to DEFRA, as the department doesn't have any functions on this, so we've passed them on. And
you've deemed it relevant to tell us that you've had those concerns and passed them to DEFRA, but the department hasn't considered it. It's been very much almost a messenger in taking those concerns and handing them over, but not taking those views into consideration and forming its own view.
Well, we have passed them on because the matter is reserved, and it's not a matter for DERA to consider. However, we have engaged with stakeholders. Brian, do you want to has been attending meetings with stakeholders?
I suppose we know that this reserved matter and sits right there at the minute, and the applicability of it here will be resolved in due course in the competent authority, as you touched on. We're waiting on that clarity on that, but aside from that, we've had contact, or I have had contact with a number of stakeholders, basically the meat processors and the grain trade organisation. That's the two that I have had. Just raising just their concerns about what they need to do to get prepared for it, and I suppose we've passed them on to DEFRA similarly, them concerns, and there's been one stakeholder meeting I have attended with DEFRA and the meat organisations, or the meat processors, and basically looking at how potentially what's going to be required here going forward, and what scope and work can be done in advance so we're ready to move once we know all these things, who's going to be the competent authority, whatever else. So there's been a bit of very provisional work done on that, but that's as far as it went so far.
I'm reassured, let me say, that there is that engagement that has gone on, and I would probably hope that it informs some of your thinking around this, but I am reassured to hear that that's going on. Can I ask then, and I understand that this is minor compared to the overarching legislation, but given the lack of clarity around how this will be applied to Northern Ireland, have the department considered asking the UK government to request a stopping of the clock on this?
At the minute, no, we're waiting on clarity. The UK government sits with it, as Catherine has touched on. It's a year down. Obviously, the medium and the larger processors or larger operators are planned for the end of this year, next summer for the following, or summer 27 for the following year. With the simplified declarations that are proposed here for the micro and small operators, and I think we're looking here, if this becomes applicable in Northern Ireland, should this be, you're looking at, there is a simplified declaration there that should be fairly achievable. It shouldn't be too big to achieve, and obviously the other side of it is the grain imports, and that's the other side of it. So you're looking at two things: how can we get our cattle killed onto the market, and they have put simplifications there, and I suppose what's happening, and we're waiting for that simplification review coming at the end of April to further flesh that out. It seems fairly straightforward, or if it ever comes to us, and should it come to us, and that's ifs and buts, our traceability database should hold the information necessary to provide the assurances necessary to provide the declarations that are needed as regards to diligence statements. And with the proposed knock-on or lessening of the requirements for downstream operators that's proposed in the simplification, that takes it away from the meat processor then as well to put anything else on board. So it should be deliverable in the time frame that we have based on what we see, and it's very early, just scoping out, and it's very early, and it depends, but we're waiting on clarity from DEFRA because it's their responsibility at the minute, and I suppose whenever they decide to tell us or tell Northern Ireland, who is the competent authority, then going forward for enforcement here, we'll take that forward.
I accept that, and as I say, it was heartening to hear that there was that engagement, because I think, yes, even where DEFRA are the authority on this, I think it's important that our local departments with the knowledge and contacts within Northern Ireland do engage in that, and I'm glad to hear that has been happening on some level. Thank you very much, Chair.
Peter?
Great, thank you very much, Chair. Thanks for coming, folks. Just in terms of, Catherine, you were obviously at committee before Christmas, and Dr. Egan had asked a question there just for clarity. Does our Chief Veterinary Officer sit on that committee? And he said he's attended meetings with DEFRA and stakeholders that have been on the UDR. UDR. Brian, I was listening to your earlier comments there. Was there a meeting or was there a couple of meetings? What has been your level of engagement based on what Catherine said at the previous committee?
There was one. I had met the meat industry, had contacted me, but we have a fairly close relationship because we're working day and daily with the meat sector, so that's not untoward. It was just an agenda item on a meeting of many agenda items. The UDR was how are we going to prepare for it, because obviously they were getting questions from their retailers, basically how are we going to comply with UDR. So, and that's why, Catherine, when we had to forward them queries up to DEFRA because of the responsibilities. But aside from that we had one meeting subsequent to that with DEFRA and the meat sector, meat industry here, NAMEA, and a few GB bodies, APHA and others, and they're looking basically at their scoping out proposals on what they think will have to be done to deliver the assurances as regards to diligence statements that are needed. And it seems to be achievable at a very high level, but the detail, we haven't got the proper detail yet. But at the minute, what we do see is it should be deliverable.
Okay. So, I mean, obviously the act that we're discussing today, and I don't want to stray, is about the extension. I mean, the stakeholders, they have concern about the original proposal. Is that what their concerns are?
Their concerns weren't so much about the proposal as about how they're going to meet the requirements. So yeah. What was the requirement that was going to be placed upon them? Mm-hmm. What information were they going to have to do? And before we got any extension stroke simplification, it was a lot more onerous at that time. Yeah. With this more recent version, the simplification of it has been would lessen our concerns a bit. But we're still waiting for the detail ultimately on the whole thing.
And in terms of then your engagement with DEFRA, because I did ask Catherine these questions at the time. Obviously, the information that we got from Dare, and I was a little bit frustrated about it, was simply a 3-page document that quoted a lot of just quotes from DEFRA, really. Now, I understand the context of that DEFRA is the lead authority in the nature of it being resolved a reserved matter. Have you or the Minister have had any direct engagement with the DEFRA Secretary of State regarding this proposal or the EDR impact?
I have had no, or nor the Minister has had any direct, that I'm aware of, as any direct contact from the DEFRA Secretary of State regarding the applicability of deforestation across Northern Ireland at the moment. But
sorry to cut across. Not with the Secretary of State, but Minister Muir meets regularly with Baroness Heyman of Ollock, who is a DEFRA Parliamentary Under Secretary of State, and he has raised the concern that he's received from stakeholders, and just made the point that stakeholders need urgent clarity on the application of EUDR in Northern Ireland. So he has, not with the Secretary of State herself, but he has raised this in numerous meetings with DEFRA ministers.
And in terms of clarifying then, Catherine, who the competent authority is, do you feel confident that the Minister has raised that with the Under Secretary of State?
Yeah, well, he has raised around the clarification, you know, so yeah, we're waiting to hear, and DEFRA ministers have assured that they will give information, that they will give the information as soon as it's available to stakeholders and to ourselves.
Okay.
I think at the moment they're considering the approach to deforestation across the UK, so we're waiting on that as well.
It still sounds, and it's not a criticism necessarily of you or particularly of DARE, it still sounds quite vague to me in terms of trying to get a level of detail around this. I remember a quote that I read out to you about that came from the DARE minister. He said we still require urgent clarity on the extent to which the EU deforestation regulation, it still seems to me quite vague and quite sort of staring into something that we don't really know what the context is and what the outcomes are going to be. But anyway, no, thank you very much for your evidence. That's me, Chair.
Thanks for coming on, folks. If I hear you right, you're saying that you welcome the delay of 12 months because that is likely to provide additional clarification. Yes?
Yeah.
Yes,
It gives time for businesses and for us to get the clarification from DEFRA. As to the applicability.
And the engagements with the processors, can we take it that they are routine? That's part of routine business, the discussions that you have had?
We routinely, with NAMIA, would be a routine stakeholder of ours and would meet them on a number of fronts. So it would be, if they're available to be discussed as and when required.
Thank you. And the outcome of those meetings, including the engagement on this issue, has been relayed back to DEFRA?
Yes, as Catherine's highlighted that on the meetings with the ministers, or Baroness Hayman as well, that the clarity required for industry.
Yes. And you have confidence in the robustness of DERA systems to handle the outcome of the 12-month period and the new processes and systems that are likely to be put in place?
Based on what I see so far, but I haven't got the detail yet. But if it's a one-time simplified declaration from farms, from small and micro operators, it should be achievable. Fairly straightforward, and it'll probably, with the information, we should have the information there. But the information should already be on our databases in Northern Ireland for all these small and micro operators. We'll have to look at the medium-sized operators and where that line splits potentially. So what moves from small into medium, and that might be a wee bit more onerous for some of them people, the real the big farmers. But that's where the clarification's just. We're waiting for that yet.
Direction of travel, as we understand it at this point in time, is towards simplifications.
That's what's pointed to, and the EU are doing a review. They're supposed to publish a report at the end of April 26 on that simplification, and particularly in relation to the small and micro and small operators.
That's everything, Ciara. Thank you.
Jonathan?
Thank you, Chair, for letting me come back in. Obviously, the overarching legislation, EUDR, predates the committee. Was there any conversations about that with the industry? Obviously, you can talk about it now through this committee and through other systems that have been put in place, but pre that, was there any opportunity for that stakeholder engagement?
EUDR had always been referenced as something coming out there, it's on the horizon. But it's the same thing. It was always never really the detail wasn't there, nor was how it was going to apply in Northern Ireland, because that was reserved matters we touched on. So it never got to the point of any detailed discussions on our side.
So, like in any of these discussions, and I've seen it before, industries hope that is if they have a problem with the overarching legislation, that delays enables those problems to be solved. Yes. Okay. I'm right in that theory. So therefore, those that wish to raise concerns about it will use the extension to try to point to the concerns and whether they can be overcome or not. That's a fair point. So those that are engaging now in raising their concerns about the original overarching legislation are using the extension period to voice their concerns about it.
they're basically everybody wants clarity on what the requirements are that's going to be placed on them, how they comply with how they're meant to comply basically.
The reason I ask you that point is that sometimes we get very fixated on the principle of, oh, this is only to talk about the specific, which is the delay, rather than what is the delay about, or why is industry concerned or having problems with it. So if you could take me back to actually David Brooks' point, your engagement with processors and others, could you really simplify for me how the concerns manifest themselves? So is a concern about costs, both direct or indirect, whether that's bureaucracy? Is it concerns around supply chain? Can you really distill that for me, Brian, what that concern looks like?
And it goes back to, and this is, we're taking it really back a further step.
Yeah.
They want clarity. They know EUDR is coming in, and EUDR basically is around, it's, I suppose, the EU, regarding biodiversity, climate change, and the impact of deforestation on that. And that's where it comes from, and any products that potentially can cause that. And they want to know, they know they're going to have an obligation placed on them to assure the market, before they place products on the market, that the products are compliant. And I suppose they want clarity on what they are required to do.
They want,
so what's actually required? What do you expect me? What's A, B, C, D? What do I need to do here? And what checks are going to be done on me to ensure I comply? So that's at the high level it was, because we've never got into that detail yet, until these things have come out here.
The concerns, if I'm getting you right, is only about how we comply rather than actually what's the impact. So, for example, if I could be taken downstream, what changes for the specific processor that would give the concern about whether or not it'll have a cost impact or supply chain impact?
It's unknown.
Okay.
It's as simple as that. It was unknown at the time, and I think now with this delay and with the simplification that's proposed here and the simplified declarations, it definitely will ease the minds on them, and they're waiting on April time to get the final report out from the Commission, really, and then whatever happens then, that's whenever they really have to get the ball rolling. But I suppose from their point of view, they're planning a year in advance. They want to get ready. They want as much time as possible to get their systems in place, to provide the assurances to put product on the market. And that's what they want. And the more time and the more clarity we give them, that's the best.
Thank you. Thanks, John.
Steve?
Yeah, thanks very much indeed. So just to sort of get my mind around this, everybody's still seeking clarification because we don't know what's going to happen until April 26th when they come out with a final detail of it. So what we're being asked to do here is to approve regulations that haven't been finalised yet.
The regulations have been finalised.
But the
regulation about the delay and the simplification that are being introduced, they're finalised. If the review at the end of April is also accompanied by legislative proposals, then there'll be a new consideration of a new regulation to introduce further simplifications.
So we don't know yet what the simplifications are likely to be.
Well, we know what they are currently. They could be subject to change in a few months' time based on the review.
So we don't know yet what they're. So basically, if I was somebody who was relying on this, I'm not going to know until April what the likely changes are likely to be.
You probably know broadly what they're going to be, right? Broadly what's there from that most recent one is the simplified declarations that we're going to have in place for small and micro operators, and we're also going to have the no requirement for the downstream operators, which are basically the meat factories, to do anything further. Because the person putting the animals in there will have to do the simplified declaration.
They can't do any of that implementation till after April, can they?
They can't. They're not going to really know what they're doing for definitively yet, and if there's anything further. And I suppose that's what they're waiting on. But it's
basically to summarise, the regulation is in. We just don't know what it's going to look like,
and what it's going to look like operationally and implementation. What it's going to look like yet. And we have an idea, but we're still at the early stages of that.
And there's actually no real point of us asking for any more information because you don't know anything until after April.
Well, we'll know something. You'd like to think that, hopefully DEFRA over the next number of months will be putting in place systems in place broadly along what we have, because we can start doing. There should be hopefully time to do a bit of work now in preparation so that your IT systems are able to adapt to whatever's going to come down the road at it. That's the ideal scenario would be. So the sooner we get clarity, the sooner we're in a position to act.
Thanks, Mark.
Okay, thank you. Any other questions, members? No? Okay. Well, can I thank both Brian and Catherine for your attendance here today.
Thanks.
So, members, under paragraph 8 of Schedule 6B to the 1998 Act, the committee must decide today whether or not to hold an inquiry into the published Replacement EU Act that has been notified. Should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So, can I say to members then, having had regard to the legal advice on whether it appears likely that the Replacement EU Act significantly differs in whole or in part from the content or scope of the EU instruments which it amends or replaces, and the departmental assessment on whether it appears likely that the Replacement Act would have a significant impact specific to everyday life of communities here in a way that is liable to persist, can I ask members, do they wish to hold an inquiry into Regulation EU 2025 2650?
I advocate for no.
Sure, whilst I understand that this Act is a delay which most people will want to see because they have problems, it doesn't negate the fact of the huge concerns that I and others have expressed regarding the primary and overarching legislation. So with that in mind, and on balance, I would propose that we do hold an inquiry into this because we don't know the prospective impact that it might have on the agri-food industry given in relation to the parent regulation. Also given the fact that we weren't established when that original legislation was passed, it would be an ample opportunity for us to delve further. So I would propose, rather than what appears on the face of this to kick the can down the road, that we would hold an inquiry.
Okay, I'll second that.
It's a proposal.
Yeah.
Any other comments from members? So we'll just go to a show of hands on your proposal then. Okay. So those in support of the proposal by Jonathan to hold an inquiry? Okay. Okay. And those not in support to hold an inquiry?
Okay, so the question is an inquiry into Regulation 2025-260. Ayes, we have David Brooks, Jonathan Buckley, Peter Martin, Steve Aiken. Noes, we have Ciara Ferguson, Declan Kearney, Cathal Boylan, Owen Tennyson, Kate Nicholl. So the proposal isn't carried, therefore, Declan, your proposal wouldn't be taken then.
Okay, thank you, members. Do you want a comfort break or are you happy to proceed?
How much further we got, Chair? We're on the correspondence yet, or we got
5
hours?
We have
one more.
One more
the
evidence
licensing for
session.
crisis management evidence session.
Yeah, let's
Keep
go.
going.
Go.
Who's all content, yeah? Okay, members, so we're going to move on to item number 14 on the agenda, which is Regulation EU 2025-2645 on compulsory licensing for crisis management, and we're going to have departmental oral evidence. Can I inform members that this item will be recorded by Hansard? And can I refer members to the relevant papers at pages 259 to 312 of your meeting pack? Can I inform members that an assessment of impact from the Department of Health can be found at pages 304 of your meeting pack? An additional annex to this assessment of impact was received from the Department of Health this morning and has been circulated to members via an email. Can I inform members that the Cabinet Office officials have stated that they are working with the British Government's Intellectual Property Office on the explanatory memorandum for the published EU Act. This will be provided to the committee as soon as it's available. A summary of the committee's consideration of the proposed EU Act can be found at pages 260 to 261 of your meeting pack. So can I warmly welcome Sean Curley, who is the Principal Pharmaceutical Officer with the Department of Health. You're very much welcome and Happy New Year, Sean. And just whenever you're ready, I'm asking you to brief the committee.
Happy New Year, Chair, and thanks for being ahead of schedule. You got my New Year's resolution up and running early, had to run up that hill. So thank you very much, Chair, and good morning, members. Thank you for the opportunity to provide the committee with the Department of Health's current understanding of Regulation EU 2025-260 2645 of the European Parliament and of the Council of 16th of December 2025 on compulsory licensing for crisis management, which also amends Regulation EC number 816/2006. So my name is Sean Curley. I'm a Senior Principal Pharmaceutical Officer in the Department of Health, and my role today is to provide the committee with information regarding any anticipated impacts of this regulation in Northern Ireland NI from a health perspective. So as members will be aware, Regulation EU 2025-2645 on compulsory licensing for crisis management and amending Regulation EC number 816/2006 was adopted on the 16th of December 2025 and was published in the Official Journal of the EU on the 30th of December 2025. The Department of Health only has an interest in the amendment to Regulation EC 816/2006 on compulsory licensing of patents relating to the manufacture of pharmaceutical products for export to countries with public health problems, which applies in Northern Ireland via the Windsor Framework Annex 2, Section 7, entitled Others. While intellectual property, IP rights, patents are a reserved matter, the Department wanted to ensure that any amendments to Regulation EC 816/2006 would not have any negative impact on the availability of medicines in NI. As a consequence, the Department has been working closely with the Department of Health and Social Care, DHSC, and IP Office to understand the application of this legislation in NI. As a way of background, a patent owner can stop others from copying their innovation without their permission. Patent owners can choose to enter into voluntary agreements with other businesses to allow them to use their innovation, for example, to allow them to manufacture their patented medicine. However, governments can issue a compulsory licence which permits third parties to manufacture or use patented technology without the consent of the patented owner under certain circumstances. So when published in 2006, Regulation EC 816/2006 established a procedure for granting national compulsory licences within the EU in relation to patents concerning the manufacture and sale of pharmaceutical products when they are intended for export to eligible countries. This legislation brought into force a decision made by the World Trade Organization, the WTO, on trade-related aspects of IP, known as TRIPS, which sets out the requirements that must be met to allow countries to produce medicines for export to countries with health problems where those countries do not have manufacturing capacity to produce the medicines that they need. The amendment to Regulation EC 816/2006 set out in Regulation 2005-2645 introduces an EU-wide compulsory licence of patents relating to the manufacture of pharmaceutical products for manufacture to countries with public health problems. At the time of the UK's EM in June 2023, an assessment considered its impact if it applied in NI. Although the impact was expected to be limited, following publication of the regulation, there is now clarity that the EU-wide compulsory licence will not apply in NI, as there is an exemption under Article 18C. This means only a national compulsory licence granted by the UK competent authority could apply across the UK. As the new EU-wide compulsory licence will not apply in NI, and a national compulsory licence can continue to be granted and apply across the UK, the Department's current understanding is that this regulation should not have a significant impact on everyday life of communities in NI. Through collaboration with the Department, we're also aware that the UK Government is planning to provide a refreshed EM, as you have stated, on the adopted legislation in due course. Finally, and I know members had discussed medicines and vaccines previously, it is important to clarify that a medicines marketing authorisation, i.e. the product licence, is granted and authorised by the Medicines and Healthcare Products Regulatory Agency, the MHRA, for the whole of the UK under Windsor Framework arrangements that came into force on the 1st of January 2025. The authorisation of a medicine differs to a compulsory licence under IP rules, and a medicines authorisation was never under the scope of this regulation. This means all medicines, including vaccines or medicines that are required during a pandemic or a health emergency, will continue to be licensed UK-wide by the MHRA, regardless of what amendments are made to Regulation EC 816/2006. Therefore, the Department's current understanding is that the EU-wide compulsory licences granted under Regulation EU 2025-2645 will not change NI's access to medicines and vaccines that are available in the UK, nor change the UK's current national compulsory licensing regime relating to the manufacture of pharmaceutical products for export to countries with public health problems.
Thank you, Sean. Jonathan?
Thank you, Sean. And obviously Article 24 makes your life a lot easier before the committee today with the exemption for Northern Ireland. But in relation to, I asked this question earlier, and you may not know the answer because it may well come forward with that UK explanatory memorandum, but it does have a requirement for UKG to take steps to ensure that products manufactured under the EU compulsory licence don't enter Northern Ireland. Does the department have any understanding of what enforcement or protective measures that would look like to ensure that that happens?
So those, I wouldn't know too much about that if I'm honest with you, but those products, when they are being manufactured under an EU licence, if it is granted, is for a country that does not have the capacity to make those medicines. Thankfully, we're within the UK and we do have capacity, generally speaking. Obviously, well, we hope if there's a health emergency or a pandemic that we do have capacity to make such medicines. So the need for us to re-export products from, it should be minimal, and I'd be surprised if it has any impact. But I'll let the UK's EM possibly look into that.
Thank you very much. Thanks, Joe.
Yeah. Thank you. Members, any other questions? No? No further questions, Sean, so thank you very much.
Thank you very much.
And enjoy
the hill this time.
again, or you can walk.
All the best, man.
It was hardly worth the run, was it?
Good step count up.
Okay, members, so under paragraph 8 of Schedule 6B to the 1998 Act, the committee must decide today whether or not to hold an inquiry into the published replacement EU Act that has been notified. Should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So having regard to the legal advice on whether it appears likely that the replacement EU Act significantly differently in whole or in part from the content or scope of the EU instruments which it amends or replaces, and given the departmental assessment on whether it appears likely that the Replacement Act would have a significant impact specific to everyday life of communities here in a way that is liable to persist, can I ask members, do they wish to hold an inquiry into Regulation EU 2025-2645?
No. You sure now? Oh, I am
Everyone
sure
in
that
agreement,
one.
yeah? Okay, thank you, members. So just to advise members that the committee's decision will be published on its webpage. Okay, just move on. So we're going to move on now to item number 15, which is COM 2025-747, and it's a proposal for a regulation on monitoring and controlling drug precursors. If members are content, I will deal with items 15 to 21 on the agenda together, as these items are recently notified proposed EU acts. All of these proposals were notified to the committee on the 2nd of January 2026, except COM 2025-747, which was notified on the 11th of December. So I will now list these proposed EU acts and their agenda numbers, if that's fine with members. So item number 15, COM 2025-747, as I had noted, is monitoring and controlling drug precursors. Item number 16, which is COM 2025-780, and it's on the production, labelling and certain rules on trade with third countries. Item number 17, COM 2025-993, on the simplification of technical requirements and testing procedures for motor vehicles. Item number 18, COM 2025-1020, which is on the extension of certain data protection periods. Item number 19, COM 2025-1021, is on the simplification and strengthening of food and feed safety requirements. Item number 20 is COM 2025-1023. It's on the simplification of rules on medical and in vitro diagnostic devices. Item number 21 is COM 2025-1030, on the simplification and strengthening of food and feed safety requirements. So members, can I ask members, are they content that legal advice and an initial departmental assessment of impact are requested on all these proposed EU acts with a time frame of 4 weeks in order to assist the committee in deciding on whether to monitor each proposal?
Great.
Great. Yeah, thank you, members. Can I ask members, given the volume of proposals being notified, are members content to revise our processes so that legal advice and an assessment of impact are automatically requested by the Secretariat upon receipt of notification within a time frame of around 4 weeks? Yeah, members? Agreed, yeah. Members will be informed that the proposed acts have been notified in the usual way via the notification email that issues on a Thursday, okay, members? So just agreed, our processes, well, those processes will be updated accordingly, so thank you, members. So we're going to move on now to item 22, which is a draft response, the review of Standing Order 59A. Can I refer members to the correspondence from the Committee on Procedures regarding its review of Standing Order 59A and the substitute member arrangements for this committee? And this is at page 921 of your meeting pack. A draft response to the Committee on Procedures is at page 923. The letter was drafted on the basis of the outcome of discussions at our informal meeting on the 20th of November. Can I ask members, are they content to issue the response as drafted? Yeah, members content. Thank you, members. So we'll move on to item number 23, correspondence. Members, there are 9 items of correspondence at items 23.1 to 23.10, and I'm just going to draw attention to a number of these. So item 23.1 at pages 9 to 8 to 956 is a copy of correspondence from the British Government to the Speaker regarding its response to the independent review of the Windsor Framework, the Murphy Report. Can I inform members that legislation will be brought forward to deal with scrutiny timelines relevant to this committee? Officials here will meet with Cabinet Office officials at the beginning of February, so it is hoped that further information on how things are to progress will be provided at that stage. Can I ask members, are they content to know? Yeah, thank you, members. Item 23.6, and it's at pages 977 to 978, is correspondence from the Assembly's Public Engagement Manager inviting the committee to participate in this year's Balmoral Show, which runs from Wednesday the 13th of May to Saturday the 16th of May. Members, because of the nature of our work and the possible need for us to go into private session, a committee meeting on site is probably not viable. However, I would like to ask if members wish to participate in some format, for example, to engage with the public, to explain its work and how it operates, and if you wish to do this, maybe what days or times would suit some principle. Would members like the committee to engage? Yeah.
Through the chair, it might be worth, because I know some other committees are thinking of going to Balmoral Show as well, so it might be worth maybe the clerk having a chat with some of the other committees just so that we deconflict or get the timings right.
Yeah. Awesome.
Thank you, Chair. Yeah, look, it was a very helpful event last year. It's probably more specific towards the Department for Economy and the likes of DERA, or sorry, the Department for, or the Committee for Agriculture. I would suggest probably the most effective way is that, particularly because this committee meets on a Thursday, is that if members wish to attend, you know, it's more of an informal style engagement, even out and about and talking to people, particularly in the Assembly tent space, that just be made available, that members, you know, from the committee can attend to do that. That's the way it was for ourselves with the economy. You know, we meet on a Wednesday, so we met down there on a Wednesday. It suited us for that. But other committees operated on the basis that, you know, their members attended, whoever wanted to go, and there was a bit more of an informal engagement rather than formal style meetings.
Yeah. Okay. David, if you want to comment.
Yeah, I agree with that, Johnny, in terms of most of us will probably, there's from Belfast maybe slightly less than others, but I spent a long time in work for Diane and Europe at the Balmoral Show. A lot of reps will be there throughout the course of the show, so that more casual is probably a good approach. But otherwise, unless there's some kind of vision for what they would like the committee to be doing at it, in which and when they'd like us to engage, how they'd like us to engage. Because the most obvious one to me would have been for a committee meeting there, but understanding the problems around that, you know, it's. I think if any of us are at Balmoral Show, there'd not be a problem with us calling by and giving some of our time to answer questions or do whatever they think that engagement would be most fruitful for those attending. But yeah, unless there's a proposal for how they envisage this happening or what role they would like us to have. I think that more casual engagement is probably the way forward.
Comms is actually coordinating all of this, and I take your point about that sort of more informal engagement. And a committee meeting there, we wouldn't know until the week before whether we need to go into private, so that really isn't viable for us. But what we could do as secretariat staff, we could attend and we could arm you then with the information in case people ask you. So we would be the formal part rather than yourselves, but we would provide you with the information if people ask you questions.
If there was a proposal that they wanted to do something at a particular time, I'm sure most of the parties represented could make sure that one of us is there at least or something like that. But other than that, I think that sounds like a way forward.
Okay. So we're content then that it's going to be informal. We'll leave maybe the day, I'd say specifically, to yourselves working with the other communication teams and the other departments and what they're doing, and it'll be an informal session, and all members, if available, will be able to pop in with yourselves. Is that okay? Yeah. Okay, thank you, members. So as in relation to correspondence, members, do any other members want to raise any other items on the agenda at this point? Steve?
Mr. the Chair, sort of the letter to you from HM Treasury referenced the Union Customs Code. Sir Humphrey's obviously written it the way it comes across, and but again, it's interesting there. He talks about the €150 low value exemption and what's happened in the autumn budget as well. So obviously, there's quite a lot of. I know it's classified official, but there's quite a lot of sort of nuggets in there that I think are quite interesting. And I think it might be useful. I don't know if it's been circulated to the economy or the agriculture committees, but it might be useful to circulate it to them, because I mean the discussions about ICS2 and sort of the declaration systems, where HMRC are working and the rest. I think it would be quite useful if at least those committees had a view of it as well, for information of where we are rather than any definitive answers.
Yeah, I think members content. Yes, we'll forward that, Steve. Thank you. Any other members want to raise? No? Okay, members, so we're just going to move on to item number 24, Chairperson's Business. Just to inform members that, as previously agreed, myself and the Deputy Chair will meet with the Minister for Economy to hear about the Department's review of its internal procedures and working relations with the British Government, and this meeting will take place later on today. So move on to item number 25, any other business. Do members have any other business? Okay. So item number 26, which is the date, time and place of next meeting. So obviously the next meeting will take place on Thursday the 15th of January at 10 a.m. in back to room 30 in Parliament Buildings, members. And I can now just thank all members for your attendance today and to adjourn the meeting. So.